Sports governance. Sports awareness. Sports accessibility. Sports facilities development. Sports linkages. Institutionalization of the Philippine Sports Institute. Legislative initiatives and interagency collaborations. Bahagi na ng buhay nating mga Pilipino ang sports. Mula sa panahon ng unos, sa tamis ng tagumpay, sa kabila ng pagbabago ng buhay, ang Philippine Sports Commission ay patuloy na magigilingkod sa sambayanan at atletang Pilipino.
Hi, I am Arleo Magtibay Jr., Executive Director of the Philippine Dispute Resolution Center Incorporated, otherwise known as PDRCI. I will be discussing with you in this session the game changers in resolving sports-related disputes in the Philippines, the PDRCI Sports Mediation Rules, and the PDRCI Sports Arbitration Rules. I am a lawyer by profession, and my practice specializes on litigation and dispute resolution, intellectual property, and sports and entertainment law. As an athlete-turned-lawyer, I understand the importance of having lawyers who specialize in sports-related concerns to ensure that the rights of stakeholders in sports are protected. However, unlike other jurisdictions, such as the United States and in Europe, sports law is still an emerging field in the Philippines. Currently, it is not common for Filipino athletes to consult a lawyer before entering into contracts. Needless to say, athletes who do not consult a lawyer prior to signing a contract generally start at a disadvantage when the dispute is brought to court. Thus, to help ensure that the rights of stakeholders in sports are protected, especially the athletes, we at PDRCI have led efforts to introduce sports mediation and arbitration in the Philippines as a means to resolve sports-related disputes. In this session, I will give a brief introduction on PDRCI to give you an idea of who we are and what we do. Then, we will have a short review on alternative dispute resolution, or ADR, focusing on mediation and arbitration, which were topics of the earlier sessions you've attended. The quick recap is intended to prepare you for when I give a brief overview on the PDRCI sports mediation rules and the PDRCI sports arbitration rules. Now for the brief introduction on PDRCI. You may be wondering, why should I even bother to know about PDRCI? I offer you this simple answer. It is because PDRCI is the only institution in the Philippines which has 1, both sports mediation and sports arbitration rules in place, 2, offers sports-related dispute resolution services, and 3, a roster of accredited third-party neutrals who specialize in sports-related disputes. PDRCI is a non-stock, non-profit organization incorporated in 1996 out of the Arbitration Committee of the Philippine Chamber of Commerce and Industry. For 25 years, it has provided quality ADR services to the Philippine business community. PDRCI advocates the use of arbitration and mediation, as well as other modes of alternative dispute resolution in settling commercial disputes, both domestic and international. It offers ADR training and accreditation, holds seminars and workshops, administers PDRCI arbitrations, and assists in ad hoc arbitrations, appoints ADR neutrals, and provides a host of ADR services. Within PDRCI, the Committee on Sports Arbitration is in charge of the institution's sports dispute resolution portfolio. It is composed of 15 sports law and dispute resolution specialists and well represents the various stakeholders in sports, including the PSC, the POC, and GAB. The committee members regularly met for close to a year to come up with the first ever ADR rules for sports-related disputes in the country. PDRCI Sports Mediation Rules, which were approved on March 17, 2021, and the PDRCI Sports Arbitration Rules, which were approved on October 18, 2021. The committee has conducted the first sports mediation training webinar, a 5-day specialized training on mediation last August, which produced the first 12 PDRCI accredited sports mediators. As mentioned earlier, the committee will soon offer a sports arbitration training seminar. Now we talk about the modes of dispute resolution. There are 2 general modes of dispute resolution: litigation, which is generally regarded as the traditional mode, and alternative dispute resolution, or ADR. Litigation in court is what most people are familiar with, either because they saw this on TV or the movies, have heard of it from other people, or because they or people they know have had cases before the courts. The simple definition of litigation is that it is the process of taking a case to a court of law so that judgment can be made. The other mode is ADR. What is ADR? It is a spectrum of less costly and more expeditious alternatives to litigation, where a neutral party assists the disputing parties in reaching a solution. So ADR allows for more creative and collaborative solutions than that of a traditional litigation. Why is it a spectrum? Because there are several modes of ADR, as you would see on your screen now. Towards the left, you would see the more informal or consensual or more collaborative dispute resolution mechanisms, such as negotiation. And towards the right are the more formal, adjudicative, or more adversarial proceedings, such as arbitration and, of course, litigation. Going from left to right, of course, there will be an increase in transactional costs and a decreasing control of outcome by the parties. So Republic Act 9285, or the Alternative Dispute Resolution Act of 2004, defines ADR as any process or procedure used to resolve a dispute or controversy other than by adjudication of a presiding judge of a court or an officer of a government agency, okay, in which a neutral third party participates to assist in the resolution of issues. This may include arbitration, mediation, mini trial, or any combination thereof. Okay? So unlike litigation, ADR is governed by the agreement of the parties. Stated otherwise, the parties agree to go into ADR. So what are said to be the most common modes of ADR? These would be arbitration, mediation, and a combination of both. Okay. Now let's take a look at mediation. The ADR Act defines mediation as a voluntary process in which a mediator, selected by the disputing parties, facilitates communication and negotiation, and assists the parties in reaching a voluntary agreement regarding a dispute. The PDRCI Sports Mediation Rules also provides a definition for this, which states that mediation under these rules is a voluntary, confidential, and non-binding private dispute resolution process in which a mediator, who shall be a qualified neutral person selected by the disputing parties or appointed under these rules, assists the parties in reaching a voluntary agreement regarding a dispute. The ADR Act defines arbitration as a voluntary dispute resolution process in which one or more arbitrators, appointed in accordance with the agreement of the parties, resolve a dispute by rendering an award. So that's the important part. Okay? Arbitrators resolve a dispute by rendering an award. The parties may also agree to a combination or hybrid proceedings, such as mediation arbitration, or MEDARB, which is a two-step dispute resolution process involving both mediation and arbitration. Now that we have completed that recap on mediation and arbitration, which were covered in your earlier sessions, we are ready to proceed with the overview on PDRCI Sports Mediation Rules and the PDRCI Sports Arbitration Rules. Okay? The PDRCI Sports Mediation Rules was approved on March 17 of this year, 2021. The PDRCI recognized that there is a need to offer an effective alternative form of dispute resolution for sports, considering its specialized needs in order to achieve a quick, efficient, and inexpensive settlement of a dispute relating to sports. Okay? So that is the purpose, and that is the reason why PDRCI came up with the sports mediation rules. Now, what are covered, or what matters are covered by the PDRCI Sports Mediation Rules? It says that it shall apply to any contractual sports dispute, difference, controversy, or claim referred to mediation with PDRCI. Okay? Now, what are the exclusions? Sports disputes related to disciplinary matters, such as doping issues, match fixing, and corruption are excluded. However, the parties may still agree to submit disputes related to other disciplinary matters to mediation under these rules. Okay? So what does this mean? PDRCI, realizing that doping issues require a different standard or set of experts that will handle such matters, or match fixing and corruption, which are covered by other regulatory agencies such as the Games and Amusements Board or the regular courts as far as corruption is concerned, PDRCI has excluded this from the coverage of the mediation rules. But again, it says there that the parties may still agree to submit disputes related to other disciplinary matters to mediation. Okay? So if the parties still agree that they would want PDRCI's mediators, or that the dispute be brought to PDRCI, then that is allowed. Okay. Now, the question is how to go into PDRCI sports mediation. First, For future disputes, you can have a mediation agreement in the contract or in the rules or bylaws of the associations that you are part of. For existing disputes, you can enter into a mediation submission agreement. Okay? So how do these look like? Now, PDRCI provides a model sports mediation clause, which reads that the parties shall resolve any dispute, controversy, or claim under this contract by mediation pursuant to the sports mediation rules of the PDRCI. If there is no settlement within 30 days from commencement of the mediation or such other period agreed in writing by the parties, the dispute shall be finally resolved by arbitration under the PDRCI sports arbitration rules then in force. Okay, so parties may just adopt this model clause word for word and include that in their contracts. Or if they would want it to be part of rules or bylaws that govern their organization, then they could pattern the wording after this. Okay, one thing that you might note that in PDRCI, we just don't limit it to mediation, but we try to promote med-arb or mediation then arbitration, because we feel that if the parties are unable to, for whatever reason, are unable to reach a settlement of their dispute in mediation, then they can or they should proceed to arbitration to have an arbitrator settle the dispute for them. Okay? Next, what is a submission agreement? Okay, a submission agreement is something that the parties can execute once there is already a dispute. So how does it read? It can read as we, the undersigned parties, hereby agree to submit to mediation in accordance with the sports mediation rules of the PDRCI the following dispute. And then the parties can give a brief definition or description of the dispute between them, which they want to bring into mediation. Okay, the parties may include like a place of mediation or the language to be used in mediation, because you might prefer an English or Filipino or even a foreign language, if that is what the athlete or the parties to the dispute would prefer. Okay, then again, we always try to provide that if there is no settlement within 30 days from commencement of the mediation, then the dispute shall be resolved by arbitration under the PDRCI sports arbitration rules. This would allow the parties to still resolve their dispute, okay, if mediation fails. But this time, that's going to be through arbitration, okay? Now, what else? What if there is no agreement by the parties to go into sports mediation? Then one party can make a unilateral request in the absence of an agreement, okay? So, for example, the parties have not agreed to mediation or agreed to mediation but not under PDRCI rules, then an initiating party, the one who's filing, can ask PDRCI to assist in inviting the responding party to mediation with PDRCI. On screen now is a flow chart showing the mediation process under the PDRCI sports mediation rules. Let's take a closer look at this flow chart. Okay. A party can initiate a mediation with PDRCI by filing a request for mediation. Okay. Here. Once the request for mediation is filed, that party will be assessed a filing fee. Okay. This is just a minimal fee that helps PDRCI continue to offer its dispute resolution services. Okay. So if there is no fee paid yet, there will be no action by PDRCI. Now, once PDRCI receives that filing fee, PDRCI will now determine whether the matter or the subject of the dispute is within the scope of the rules. Okay. It is the lookout of the initiating party to study at the onset whether this would be under the rules or not. Because if these are not under the scope of the rules or within the scope of the rules, the filing party will be notified accordingly and the file will have to be closed. Now, if it is within the scope of the PDRCI sports mediation rules, the next thing that the PDRCI will have to check will be if there was an agreement for mediation with PDRCI. Okay? If there is a clear agreement for mediation with PDRCI, then PDRCI will proceed to notify the other party. Okay? Now, if there is no agreement to mediate, or there is an agreement to mediate but not with PDRCI, what PDRCI can do is that it will invite the other party to agree to mediation with PDRCI. Okay, so now it all goes to the other party. The party will either accept the request or the invitation, and that party has a period of 3 days to respond. Okay, now if that other party says no or does not accept the request or invitation, then the filing party will be notified of such fact and the case will be closed. Why will it be closed? Because as was taught to you or discussed with you previously, mediation is a voluntary process. You cannot force or compel a party to go into mediation. So if they do not accept or even just they do not respond within that period, then PDRCI is constrained to file or to close the file. Okay? Now, what if the other party accepts the request or invitation? Now, let's go to that next slide. Now, if they accept it, PDRCI will also have to check if that other party accepted the proposed mediator. Because generally, when you file a request for mediation, you will also be asked to nominate a mediator already. Okay, so the party filing with will nominate a mediator, so the other party can choose to accept that proposed mediator. When the responding party accepts that proposed mediator, then the chosen mediator shall be notified of the appointment. Okay, and once that chosen mediator is notified of the appointment, of course, the chosen mediator can either accept it or reject it. Okay, now if that chosen mediator accepts it, then you proceed. But if the chosen mediator, the mediator agreed upon by the parties, do not accept it, then PDRCI will be the one to appoint and confirm the mediator for the parties. Okay, it's going to be PDRCI and not have to go back to the parties to expedite things, because sometimes or in other mediations, when the parties are given more time to come to an agreement on a different mediator, it bogs down the proceedings. So to expedite it, if that chosen mediator does not accept, then it will be PDRCI who will choose the mediator for them. Okay, that is the first line. Now, what if that other party or the responding party did not accept the proposed mediator? Two things can happen. That responding party can either propose a different mediator or not propose anyone at all. Just be silent about it. Now, if that responding party proposed a different mediator, it goes back now to the filing party. Okay? So that the filing party is given the opportunity to either accept that different mediator or to reject it. If the filing party accepts that proposed mediator, then it goes back up here, and the chosen mediator shall be notified of the appointment and goes back to the chosen mediator, is asked whether he accepts or denies that appointment or rejects that appointment, then you go this way. If that filing party, on the other hand, chooses not to accept the mediator being proposed by the respondent, then PDRCI shall be the one to choose already. You go here. Now, if the responding party, okay, you go here, did not accept the proposed mediator, but also did not name anyone as a possible mediator, then it all goes down to PDRCI to appoint and confirm the mediator. Okay? So, if the mediator accepts the appointment, or if PDRCI chose the mediator, you proceed here. PDRCI shall now issue an assessment for full mediation fees. What are the mediation fees? The mediation fees now will cover the administrative fees and the mediator's fees. Of course, the mediator will also have his fees. But don't worry, PDRCI has really made the fees, both the administrative fees and the mediator's fees for sports mediation, very affordable. Okay? So, after this, what happens? Go down. Now, the mediation fees, there's a question if it's going to has been paid or not. Okay, the mediation fees are generally equally borne by the parties. So, hati sila, they're equally borne by the parties. Okay, but one party, if one party is unable to pay his share, the other party is not precluded from advancing that other party's share or paying for that other party's share for the mediation to proceed. Because why? If the mediation fees are not paid in full, then there will be no action and you will just have to wait. PDRCI will just have to wait until the mediation fees are paid. Now, if the mediation fee or once the mediation fee has been paid, then the mediation is deemed commenced. This is the commencement of the mediation. Okay. So that's when you start, the parties are going to be called for mediation conferences and everything. Okay. And then after that, the question now will be whether the parties are able to settle their dispute. Okay. This period from commencement until this period will take a period of 30 days. Okay. So the parties are given a period of 30 days to settle their dispute unless another period was agreed upon in writing by the parties. Okay, because as we mentioned, in mediation, the proceedings or the process are controlled by the parties, then the parties can agree to a longer period. Okay, now, if they are able to settle their dispute, what happens? The parties, with the assistance of the mediator or in the presence of the mediator, will execute a mediation settlement agreement that will embody the terms of their agreement, of their settlement. At that point, the mediation will now be terminated because tapos na. Diba? But what if the parties were unable to settle the dispute? So you go down. The next question you have to look at is whether the parties have agreed to or will agree to MED-ARB or mediation arbitration. Okay? If they've adopted the PDRCI's model mediation clause, model sports mediation clause, as I mentioned earlier, that is really a MED-ARB clause. Okay? So if they do that, then they can now proceed to arbitration. Of course, once you proceed to arbitration, the mediation is terminated because that is a different proceeding already. Okay? But if the parties did not agree to any MED-ARB clause or MED-ARB, then the mediation will simply be terminated. That's the end of it. Okay? So I hope that's clear. Okay. A few highlights on the rules. Okay. Remember, PDRCI sports mediation rules, there shall be one mediator for a dispute unless the parties agree in writing to a co-mediator. So we are allowing co-mediators, but only if the parties agree to it in writing. Okay. The mediators under our rules should be selected from PDRCI's panel of mediators in sports. As I mentioned earlier, we have the first 12 accredited PDRCI sports mediators. Okay, so you can choose from them. Why them? Because they have been trained and they are experts actually in sports law and dispute resolution. Okay, next. Important to note that the date of the payment of the mediation fee and the deposit for mediation expenses shall be considered the date of commencement, as I mentioned earlier. That once the assessment has been made and paid for, then that's when mediation is deemed commenced. Okay. The mediator, of course, may always conduct the mediation in such manner as they may consider appropriate. It is, of course, the parties control it, but the mediator is given that ability to conduct it the way that they consider it appropriate. Okay, under PDRCI sports mediation rules, parties are given a period of 30 days from commencement of the mediation to try to settle their dispute. You should remember, this is important, that mediation is always confidential. Okay. Now, in case of an objection by any party, okay, if any party objects to the mediator that has been appointed, the rules provide that the mediator shall cease their mandate and immediately notify PDRCI. Okay. So as long as someone during the proceedings will object to that mediator, then under our rules, we require them to let go of their mandate or release their mandate. After that discussion on the PDRCI sports mediation rules, let's now take a look at the PDRCI sports arbitration rules. The PDRCI sports arbitration rules were approved on October 18, 2021. So the scope of the PDRCI sports arbitration rules, it states that the rules shall apply whenever the parties have agreed to refer a sports-related dispute to PDRCI. The dispute may involve a contractual, commercial, or intracorporate issue, difference, or claim. The reference to PDRCI may arise out of an arbitration clause contained in the contract, regulation, or in a submission agreement. Or it may also involve an appeal from a decision by a federation, association, or sports governing body whose rules provide or where a specific agreement provides for an appeal to PDRCI. Okay? So those are the instances when the PDRCI rules may be used by the parties. Now, for exclusions, the rules provide that disputes involving field of play decisions, doping, match fixing, and corruption are not covered by the rules. Okay? However, we have a catch-all provision that where the circumstances so require and the parties expressly agree, any dispute involving any activity or matter related or connected to sport may be submitted to PDRCI for arbitration under these rules. Okay? So, similar with our mediation rules, we are excluding from the coverage issues on doping, match fixing, and corruption, and of course, have included the field of play decisions. Okay? But remember, there is always a catch-all provision such that if the parties expressly agree to submit a matter or a dispute for arbitration with PDRCA under our rules, then that will be allowed. Okay. Now, how to go into PDRCI sports arbitration? Similar with sports mediation, for future disputes, the parties may have an arbitration agreement in their contract or the rules or bylaws of their respective institutions or their institutions. For existing disputes, the parties may enter into a submission agreement. Okay. If you will take a look at the PDRCI's sports arbitration rules, there are several model clauses that are already provided, which the parties can just copy and paste on their contracts or their rules. Okay, so the model arbitration clause will read as any dispute, difference, or claim arising out of or relating to this contract or the existence, validity, interpretation, breach, or termination thereof shall be finally settled by arbitration in accordance with the PDRCI sports arbitration rules in force at the time of the commencement of the arbitration. This second paragraph, which reads the number of arbitrators shall be 1 or 3. The state of arbitration is parties can choose that. And then the languages are all recommendatory so that the parties are able to determine even before a dispute will arise on how many arbitrators they will have, where the arbitration will be conducted, and the language that will be used. Okay, So that is for the model arbitration clause. We have the model mediation arbitration clause. This is very similar, or not very very similar with the model mediation clause that is provided under the PDRCI mediation rules, with just this addition of the suggested provisions on the number of arbitrators, the seat of arbitration, and the language to be added in case the parties would want that at the onset. Okay. Now, there is also a model arbitration, mediation arbitration clause, which the parties can choose. Okay. What happens in an arbitration, mediation, arbitration? Okay. In situations like that, the parties have commenced arbitration, and then sometimes during the arbitration, the parties would like to resolve some of the issues via mediation. I mean, not all issues may be resolved, but they feel that some of the issues need not go through arbitration, and they may be able to settle this under mediation. So what's going to happen is those issues will be brought out of that arbitration and instead brought to mediation. Now, once that mediation is completed, whether they are able to come up with a settlement agreement, or the mediation terminates without the parties reaching an agreement, then the arbitration proceeding will resume. That's why it's arbitration, mediation, and arbitration. Okay? So you will read that in the third paragraph here, which reads, in the course of the arbitration, the parties may refer any or all of the claims or issues to mediation under the PDRCI sports mediation rules. The arbitration of such claims or issues shall be suspended upon the commencement of the mediation without prejudice to their return to arbitration. In case mediation fails, then the mediation shall not suspend the arbitration of any remaining claims or issues. Those are the claims or issues, again, that have not been brought to arbitration. Now, the rules also provide for a template for a submission agreement. Okay. So it reads, you can choose, it's a dispute, a difference, or a claim, and having arisen between the parties concerning, then you just put the, what is the subject? Huh? Then the parties hereby agree that the dispute, difference, or claim shall be referred to and finally settled by arbitration in accordance with the PDRCI sports arbitration rules in force at the time of the commencement of the arbitration. Okay, so those are the model clauses or submission agreements that the parties can copy and paste onto their contracts, okay, to bring their arbitration to PDRCI. Now, again, similar with the PDRCI sports mediation, there could be a unilateral request to bring a dispute into arbitration in the absence of an agreement. So, okay. On your screen now is a flow chart showing the arbitration process under the PDRCI sports arbitration rules. Okay. Now, let's take a closer look at this flow chart. Get the start here. Okay. Start. A claimant will file a notice of arbitration and will pay an administrative fee and a provisional advance on cost. Okay, so the administrative fees are minimal fees, again, to help PDRCI continue to offer its dispute resolution services. Okay, now, once that is done, then we will have to check if the parties have an existing arbitration agreement. Okay. If they do not have an existing arbitration agreement, then you go up here where PDRCI may invite the respondent in that arbitration to agree to submit the dispute to arbitration. And, okay, PDRCI will give the parties a submission to arbitration form and a list of arbitrators. In that case, there's a question now if that respondent will agree to submit the dispute to arbitration. If in the event that respondent does not agree, then that's the end of it. Again, arbitration is a voluntary process. Okay. Now, if they agree, then you go here. The respondent will now file a response to the notice of arbitration. Okay, but let's go back here. Okay, if the parties have an existing arbitration agreement, then instead of inviting the respondent to agree to arbitration, since there's already an agreement, PDRCI will just serve a copy of the notice of arbitration to respondent, and upon receipt again of the fees that will be paid by the claimant at the start. Now, the respondent will be given a period to file a response to the notice of arbitration, and it will be required to pay its own provisional advance on costs if the respondent will have counterclaims. Okay? So if there are counterclaims, please take note of that. Now, what happens? After the notice and the response are filed, generally, each party will be appointing an arbitrator. You're here. Okay. Now, if they have appointed it, the question now is whether the arbitrators have accepted the appointment. If the arbitrators they chose did not accept it, then PDRCI appoints the arbitrators. If the arbitrators that they've appointed accepted it, then, of course, PDRCI will notify the parties of the acceptance of these two arbitrators. We're talking about a tribunal of three here, three arbitrators. One party will appoint the first arbitrator, the respondent will appoint another one. So that is the idea here. And those two chosen, later on, you'll note that they will select the third arbitrator. Okay. So what happens is PDRCI notifies the parties of the acceptance by the two arbitrators, and then they will be given the period to challenge said appointment. Okay. Now, so let's hold that discussion there. Let's go back here. Now, what happens if each party has appointed an arbitrator? Okay. If they did not appoint the arbitrator, then you go back there. The PDRCI appoints the arbitrators for them. Okay. Now, okay. So what happens now if the PDRCI appoints the arbitrators? The two arbitrators will select the third arbitrator. Okay. And then if the two arbitrators agree on the third, okay, if they do agree, then that third arbitrator, and if that third arbitrator will accept the appointment, of course, they cannot be forced into accepting the appointment. So they have to agree to the appointment. If that third arbitrator accepts it, then you end up here. PDRCI notifies the parties of the acceptance by the third arbitrator. And of course, there will be a period to challenge that appointment. Okay. Now, if the two arbitrators, let's go back again. If the two arbitrators did not agree on the third arbitrator, or even if they've agreed, but the third arbitrator does not accept the appointment, then it is PDRCI now who will appoint that third arbitrator. Okay? So again, the parties will be given the opportunity to appoint or to make nominations. But at the end of the day, if there is no agreement, it will be by the parties or by the arbitrators chosen, then it will be PDRCI who will make that appointment. Okay? So at least that's that. Okay, so we'll go back here first, no? Now, that's on the second slide, another slide. Now, okay, we're back here. So if the party appointed arbitrators, remember, they may be challenged. Okay. If the party appointed arbitrators, that would be arbitrators number 1 and 2, if they are challenged, then the parties may appoint substitute arbitrators. You go here. Then once they are appointed, then the PDRCI confirms the appointment. Okay. But of course, it goes there. Now, if the party-appointed arbitrators are not challenged, meaning the parties are fine with them, then of course you just go straight here, no? That PDRCI will confirm the appointment of that first two arbitrators. Then you go back to this process that the two arbitrators select the third, and then question if they have agreed. If they do not agree, PDRCI will decide. If they have agreed, it's up to the third arbitrator now to accept. If he doesn't accept, PDRCI will decide again. But if he accepts, then the parties are notified of the appointment. Okay, so we're here, we're back here. So the appointment of the third arbitrator, as mentioned earlier, may be challenged. Okay, if the appointment is challenged, what happens? Then PDRCI will have to decide that challenge within 3 days from referral, meaning from notice of the challenge. Okay, PDRCI, we've shortened the period to expedite matters to just 3 days to decide the challenge. So it's either PDRCI will uphold the challenge, in which case a substitute arbitrator will need to be appointed, or it will reject the challenge. Okay, now, after that, PDRCI will confirm the appointment of the third arbitrator. Now, in the event that there is no challenge to the third arbitrator, then it just goes straight to PDRCI will confirm the appointment of the third arbitrator. Okay. It should be noted that it is the third arbitrator who will act as chair of the tribunal. Okay. Now, PDRCI shall notify the parties of the constitution of the tribunal, and it will invite the parties to commence the arbitration. Okay. At that time, once the tribunal has been constituted, the PDRCI will transmit the case file to the tribunal. We're here. Okay. And then once it's been transmitted to the tribunal shall convene the parties to a case management conference and issue procedural order number 1. Okay, so let's move on to the next slide. Okay, we are here now. So as mentioned earlier, there will be a case management conference. Okay. After that, the tribunal will set the case for hearing, during which the parties may submit the case for decision already, with or without presentation of evidence. Okay. And then after that, the tribunal will conduct the hearings. After conducting the hearings, the tribunal will declare the hearings to be closed, and then it will deliberate and issue a written award that is binding and not subject to appeal. Okay? Then after that, that's the end of the arbitration. Okay? So that is an overview, a quick overview on the arbitration procedure with PDRCI. Now, to give a better idea on the duration of the PDRCI sports arbitration, as mentioned earlier, the claimant will have to file a notice of arbitration, and then generally the respondent has 30 days from receipt of the notice of arbitration to file a response to the notice. Okay, from this time until the constitution of the tribunal, it can take to as little as 5 days to maybe as long as 30 days to form that tribunal. Okay, now, from the time the tribunal is constituted, you will have a case management conference, the hearings, the closure of the hearings, and eventually the final award. This period, from the constitution of the tribunal until the final award, is just 120 days. Imagine that, just 120 days, and you will already have a resolution of your dispute. So looking at all those periods, parties may expect their dispute to be resolved between 150 to 180 days. Imagine that versus going to litigation where we know takes years and years before being resolved by the courts. Okay. Now, okay, some highlights on the PDRCI sports arbitration rules. As you would see when you download a copy of our rules, we prescribe the use of standard forms. Okay, we've made it easier. Parties may will just use and fill out these forms for their notice of arbitration, for their response, for any reply. Again, This is to make it easy for the parties to go into arbitration with PDRCI. Now, another innovation is that our rules recognize third-party funding to finance a party share of the costs of the arbitration. Okay. This is going to be a long discussion, so I'm just going to mention it here and not discuss this thoroughly. Okay. Okay. Next is where the parties have not agreed on a number. We have a default. Okay. The default rule is that the tribunal shall consist of a sole arbitrator, so just one. We made it easier so that, again, for expediency, we just use a sole arbitrator for sports arbitration cases, except where PDRCI, in its discretion, determines that, in view of the circumstances of a case, a tribunal of 3 arbitrators is appropriate or necessary. Now, should be noted that only PDRCI accredited sports arbitrators may be appointed as arbitrators in PDRCI sports arbitrations. Okay. Another thing is that PDRCI's rules allow for summary disposition of one or more claims, counterclaims, or defenses that are manifestly without merit. We've already made resolution of disputes fast with arbitration rules, but the summary disposition can make it even faster if it is clear that the claims are without merit. So it's all there in the rules. And finally, our rules is recognized and allows for bracketed arbitration and final offer arbitration, which unfortunately, again, will need a whole session to discuss with you. Okay, but we wanted to mention that so that you can probably take a look at that at your own, you have your own spare time. Now, PDRCI also has an expedited procedure for sports arbitration. Expedited. This is mas pinabilis, so faster, okay? So prior to the constitution of the arbitral tribunal, that is prior to the constitution of the arbitral tribunal, remember, a party may apply to PDRCI for the expedited procedure where the aggregate amount in dispute, okay, does not exceed 5 million, or the dispute does not involve monetary claims, which can happen in sports disputes, or if the parties agree that they would want an expedited procedure, then they could apply for an expedited proceeding, or in cases of exceptional urgency. Okay, next. Okay, for expedited procedures, these are heard by a sole arbitrator, again, unless the arbitration agreements provides for 3 arbitrators. PDRCI may shorten the already shortened time limits, okay, to make this really fast. And then the arbitral tribunal is told to adopt a simplified procedure, and again, shorten time limits. Okay, the important part here is that the award shall be made within 30 days from the date PDRCI transmits the file to the arbitral tribunal. So how does that look like? Okay, so you have the notice of arbitration and the response to the notice of arbitration that should be filed immediately. Now, after that, the tribunal will be constituted. Again, the default is 1 unless the arbitration agreement provides for more than 1 or 3. Okay? Now, once the tribunal is constituted, the file will be transmitted to that tribunal. Okay? And then imagine the case management conference, the submission of documents, and the award, if any hearings will be conducted, it's all going to happen there within 30 days because the tribunal will only have a period of 30 days from receipt of the file to issue the final award. So what this means is that the parties' dispute may be resolved between 30 to 60 days. Wow, that's something that we wish could be done even in our court system. Okay. Now, this one is something different. Emergency arbitrator for sports arbitration. Okay, there are instances when there is a need to appoint an emergency arbitrator. Okay, when there is a need to apply for an interim measure of protection, such as imagine the idea of a restraining orders or something to that effect. Huh? So again, prior to the constitution of the arbitral tribunal, a party may submit an application for the appointment of an emergency arbitrator. Okay. Note that any decision, order, or award of the emergency arbitrator on the application shall be made within 15 days from the date in which PDRCI transmitted the file to the emergency arbitrator. Again, because this is an emergency proceeding, it's even shorter than the expedited. Under the expedited, it's 30 days from receipt of the file or transmittal of the file to the arbitrators. In emergency arbitration, it is shorter, just 15 days from the time the file is transmitted to the emergency arbitrator. That ends our brief introduction into the PDRCI sports arbitration rules. As a preview of what's to come next year, we'd like to let you know that aside from the PDRCI sports arbitration training webinar, we will soon be launching the PDRCI ad hoc sports arbitration rules. For those who are unfamiliar with ad hoc sports arbitration, these are arbitrations that are utilized during sporting events where resolution of disputes are made within 24 hours. So this is something that's really exciting, and we look forward to launching this in the Philippines. Once again, I am Arleo Magtibay Jr. of PDRCI. If you'd like to download a copy of our rules or know more about our institution, please visit our website, pdrci.org. If you have any questions on sports arbitration or sports mediation, please feel free to contact or add me in social media. So once again, thank you and have a good day.
Bahagi na ng buhay nating mga Pilipino ang sports. Mula sa panahon ng unos, sa tamis ng tagumpay, sa kabila ng pagbabago ng buhay, ang Philippine Sports Commission ay patuloy na magigilingkod sa sambayanan at atletang Pilipino.